Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and we're going to have a discussion that you might feel like we've had before. But it seems that there is either confusion or forgetfulness in the industry about which form you should use when your buyer wants to terminate the transaction. To understand this video, you have got to be aware of the distinction between the word terminate and rescind. They are not the same. When a buyer terminates a purchase and sale agreement, and the seller could terminate the purchase and sale agreement, but more often than not, by a long shot, it's the buyer who is terminating the agreement. When they terminate, that means they are exercising a contractual, unilateral right to end the transaction. It doesn't unwind or undo or take us back to the beginning of time. It just stops us dead in our tracks in this contract and says, we're done. We're not going forward. When a party terminates a contract, they have the unilateral right to do so, meaning that in order to effect the termination, all they have to do is sign a notice of termination and deliver it to the other party. With the delivery of that termination notice, they terminate the transaction, and assuming they had the right to terminate it, they are not in breach, meaning that if it's the buyer, they're going to recover their earnest money and go away. Now, set aside for a moment the fact that there's disputes over earnest money, because I'm not talking about what could happen if parties don't adhere to the terms of the contract. I'm talking about what the contract requires. So in a scenario where a buyer has an inspection contingency, for example, or a 22T, a Form 22T title insurance contingency, or maybe they have the right to terminate based on the homeowner review period under Form 22D, or they have a right to terminate based on the financing contingency. Whatever the contingency is that gives the buyer the right to terminate, when that buyer chooses to exercise that right to terminate, buyer brokers do not deliver a Form 51 rescission agreement. The use of the word rescission agreement should have tipped you off to the problem. If your buyer has the right to terminate, meaning all they have to do is sign the notice and deliver it to seller, and the contract is in fact terminated, what's the significance then, buyer broker, of you using the wrong form, the rescission agreement, Form 51, having your buyer sign that and deliver that to seller? The Form 51 rescission agreement is an agreement by the parties to rescind the transaction. Not only are you not trying to rescind the transaction, there's a distinction between rescission and termination. We're not going to go into that on this video, although Washington REALTORS has published an article on that topic, and it will be linked to this video. The reason it's significant for the purposes of this discussion for you to use the wrong form, buyer broker, is because when you deliver a rescission agreement, when what your buyer really has is a contractual right to terminate, then you are setting your buyer up for breach of contract. How on earth do we get there? Because your buyer thinks they've terminated the contract and ended it by signing this rescission agreement that you put in front of them. But a rescission agreement is not enforceable with the signature of only one party and delivery of that signature. A rescission agreement, just like its title indicates, requires the signature of two parties. It requires agreement. Buyer broker, if your buyer has the right to terminate, but you deliver a rescission agreement and the seller doesn't sign it, and then the contingency period passes without your buyer actually terminating the agreement because you used the wrong form, you have cost your buyer substantial funds in the form of loss of their earnest money. At least that's the worst case scenario. I don't know what any given court is going to say in any set of circumstances, but that, buyer brokers, is the risk. And that risk is present because you used the wrong form. Let's put a set of facts around this. Let's say buyer has an inspection contingency, and that inspection contingency is going to expire on Wednesday night at 9 p.m. And on Tuesday afternoon, they decide, I don't want to buy this property. And they say to you, I want to terminate the agreement based on my inspection contingency. And they have the absolute unfettered right to do that. And buyer brokers, instead of delivering to them the form that you should deliver to them, the Form 35R marking the box that they want to terminate the transaction for their signature, which you would then deliver to the seller, and that would necessarily cause a termination of the transaction based on buyer's right to terminate the transaction. If instead you deliver to your buyer a Form 51 rescission agreement, and you mark the box that says the earnest money is going to be returned to the buyer, and you send that rescission agreement over to the seller, to the listing broker, and even if you include an email explanation that says, based on buyer's inspection contingency, they want to be done, or they want to terminate, or whatever words you use, if you send that explanation over with the Form 51 rescission agreement, assume seller doesn't sign. And assume that by 9 p.m. on Wednesday night, seller doesn't sign. What then? By 9 p.m., the deadline for your buyer's inspection contingency, your buyer has not yet terminated the transaction. Seller is sitting on the rescission agreement. They may or may not sign it, but let's assume they don't. Now your buyer's inspection contingency is gone. How do you now terminate the transaction based on your buyer's inspection contingency? You don't. It's already gone. Are you going to have a fight over the earnest money? It's possible. How's that fight going to turn out? I don't know. But I know that if your buyer has to fight for their earnest money because you used the wrong form, that's a problem for you, buyer broker. And it's a problem you avoid by being educated as to the form you should use at the right time. When your buyer has the right to terminate the contract based on a contingency, then you must use a termination notice. For almost every contingency provided through the statewide form system, there is a corresponding termination notice. If you can't find the right form to use to terminate based on your buyer's contingency, then if nothing else, pull out a blank Form 90, which is a notice form, and write your own termination language. That still puts it on a notice form. It still requires only your buyer's signature, delivery of the form to cause a termination. Always accompany your termination notice with a Form 50, that's the disbursement of earnest money form, so that hopefully then the seller or the party on the other side of the transaction will sign the Form 50, which will be given to escrow to create disbursement instructions for the holding of that earnest money or for the disbursement of that earnest money. But really, that's a secondary issue. The earnest money probably feels like the most important issue. It's a secondary issue to terminating the transaction. Because unless and until you terminate the transaction timely, your buyer's not entitled to recovery of the earnest money. So handle termination first and accompany the termination notice with the Form 50 disbursement of earnest money. If you have any questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.